there are some builders that even today, right now, that, no one really denies people for COVID reasons. They say, listen, only the person on contract can show up. So if that person is a kid, we've had that, listen, that's what it is.
Well, and I think that that's absolutely ludicrous. Again, because of the nature of pre-construction, you're not looking at the property. You don't know what you're going to be receiving. So inspection should be a right that's granted with respect to all properties, but especially with respect to pre-construction, because again, you don't know what you're buying.
Hi everyone, and welcome to another episode of Real Talk. Today we have Mobina Basiri from Cactus Law. And what I see here is winner of the 2023 Platinum Toronto Star Readers Choice Award.
Thank you.
Well
Coming
done.
to you live.
Love it. So what we're going to talk about today is deficiencies in pre-construction. I mean, we talk a lot about buying pre-construction, buying assignment, but when actually people get to move in, whether it's condo, you go in occupancy and then close, or you go right to closing, and we're even talking about condos and freeholds. And if you were to find deficiencies, what options you have, what choices you have, and just overall, we're gonna dive deep into it because there's a lot of pre-construction coming into occupancy. Actually, as a matter of fact, this year had the highest number of occupancies in the last decade. We had just over, I think, 30,000 units coming into occupancy. So I think a lot of people, this topic would resonate to. So let's start. As we know, anything that gets built in Ontario has to have Tarion on it if it's brand new. And with Tarion, you get up to 7 years. Each year, you have different things. But let's talk about the fact that, let's start maybe with just PDI and occupancy, that when people buy, whether it's condo or freehold, detached home, they get a chance to go check the home prior to it being delivered to them. And that's PDI, that's pre-delivery inspection. To my knowledge, whatever you find there, the builder has to rectify before you move in. But I've seen a lot of units that get delivered and there's still small items left, and sometimes there's 20 of them that the buyer is what's going on. As I'll give you an example, we had a condo unit that the shower glass was not installed in PDI. They moved in, it was still not installed. We had hood covers that weren't installed, toe kicks that were not installed. There were windows that could not be even opened. So what options do buyers have, and overall, what's going on with this whole warranty situation in these cases?
Okay, well, we have some good news and some bad news. Those deficiencies you listed doesn't necessarily allow any purchaser to walk away from the transaction. Now, yes, the builder does and the vendor do have an obligation to fix those deficiencies, and purchasers do have to provide a reasonable opportunity for the vendors to fix those deficiencies. But let's just take it back, because pre-construction units are very different, as in we purchase the property technically, or the right to purchase the property prior to there being a property. So unlike a regular resale where you go in and you get to see the house and you get to see what you're buying, with a pre-construction, you're really blind to a lot of things, and you're really going on a good faith basis that things are going to be done properly. And under the Ontario New Home Warranties Plan Act, what Section 13 states that every vendor of a home warrants to the owner that the home is constructed in workmanlike manner, is free from defects in material, it is fit for habitation, and is constructed in accordance with the Ontario Building Code. Now, just because there's an occupancy permit doesn't mean that the vendor has met this burden, right? If you look at what is required to provide or to get an occupancy permit, you'll see it's really the basics. So yes, an occupancy permit is absolutely required for a property to be fit for habitation, but it's not sufficient. So yes, if there is no occupancy permit, it's not fit for habitation. But if there is a occupancy permit, doesn't mean that that's sufficient for Section 13 of the Ontario New Home Warranties Plan Act to have been met. So then we look at it and we say, well, what happens when there's breaches? What happens when there is deficiencies with the property? And what the courts have said is that for deficiencies to be considered a fundamental breach of the property, the threshold is actually very high. So it can't be just the window not working, the hood not being installed. There were situations where the clients didn't even have a fridge, and it could be argued, well, is it fit for habitation or not? And I don't even think that would meet the
Let's just
test.
pause it here. What's the requirement for getting the occupancy permit?
Okay, so let's look at what's required to get the occupancy permit. And I'm just going to bring up my notes. So if you look at it, they're pretty general. So structure of the building or part is substantially complete. Building envelope with respect to the dwelling unit is substantially complete. Installation, vapor barriers, air barriers, grading, electric supply, firefighting access routes, exits have to be complete and operational for the dwelling unit. Floor access has to be complete, handrails, guards. So really what you're looking at is fundamental safety structures of the unit, right?
So if there's no kitchen.
Yeah, it's this is not saying, if there's no kitchen, it doesn't mean that they're not going to get the occupancy permit, right? But if there is no toilet, for example, if there are no sinks, if the shower isn't installed, there could be an occupancy permit, but that property is still not fit for habitation, right? If the roads are so messed up that there's no city access, for example, all of these layers, maybe, only one of them in of themselves might not be considered a fundamental breach. But when you have significant issues and there's multiple layers,
so it's not
issues,
a black and white situation that you say, listen, you know what, if you don't have a toilet, then that's it. Or if you don't have a kitchen.
That's it. It's very difficult. It's not black and white, and buyers really have to approach this carefully. The reason being is that at the end of the day, what's considered significant deficiencies is the interpretation of the judge that's hearing your case at that time. So what you want to do is...
So you got to go all the way through the court.
Well, it depends if it's worth it or not. Yes, absolutely. But what you want to do is you want to show that you are ready but for the deficiencies, at least willing to close, right? So I told my client, I said, yes, there are significant deficiencies and we have to work with the builder. We have to provide them opportunities to fix these. But doesn't mean that, you can sit back and say, I'm not closing. No. When the closing date comes, you better have your mortgage ready. You better have your insurance ready, your title insurance, and you have to be in a position to show that you are willing to close and that you're working with the builder to provide them opportunities to fix these deficiencies. And again, unless there are such significant deficiencies that you have a list that really goes to the heart of the fact that, hey, this is not fit for habitation, it's more likely than not that you have to close, right? But we will look at some cases where the courts found that there are significant deficiencies. And one of those cases, for example, was, sorry about that. One of the cases was Mastra Key. And this case, what they found was that there were just so many deficiencies. It wasn't just one or two. There were 130 problems, some very minor, and such as dirty windows, which is nothing really, but some of them were more serious, like undersized ductwork or small, or the furnace was too small.
Really?
Yes. And 36 of those deficiencies were actually building code violations. So the magnitude of the deficiency was important, but also what's interesting is that there are other elements that go into it, which is the parties have to act in good faith, right? So if there are these significant deficiencies and then the builder is coming saying, oh, well, you don't get an inspection and you know what, we're not gonna close this, or we're gonna delay the closing to fix these deficiencies, but you have to waive your delayed compensation rights, right? That is not gonna sit well with the courts because all the parties have to act reasonably and they have to act in good faith. And on top of that is that the parties have duties to mitigate their damages. So for example, if a builder is going to come and sue a purchaser for not being able to close because again the purchaser is saying, hey, I can't live in here, this is not fit for habitation, then really the builder has to show that they acted reasonably to mitigate their damages, or else they can't come and say, oh, well, you didn't close and we're going to sue you because we sold the property at a significant reduced price. Well, how did you work with the purchaser in order to address these concerns, right? So that's really important as well. And then if you look at the nature of the deficiencies that, and again, look at these as layers, right? The more deficiencies, the more of a problem it is. But if you look at what's considered significant deficiencies, there's the magnitude of it and there's the volume of it. But I tried to put these into a group, and a lot of the cases were regarding either structural defects, water damages, foundational damages, poor installation, framing defects, mold and mildew, plumbing issues, leaking pipes, inadequate water systems, inadequate electricity capacity, and obviously the code violations. So what we're looking at is the top two issues is, well, is it safe and is it suited for the residents to be able to occupy the property? And then another layer would be, well, how much does this also affect the value of the property, and does it fit it with the expectations of the clients with what they purchased? Yeah. The value of the property issue is it's a minuscule issue compared to the other issues. But again, when you're looking at this, you have to look at the different layers that are involved.
Well, what we're talking about, the valuation, going and talking about, I would say condos mostly. One thing I've noticed is the square footages, for example, on the plan, majority of the time does not match what it's actually getting built. So if people are actually looking at, when you're buying pre-construction, the marketing floor plan that you get is got a measurement on top. It says what's the interior, what's the, let's say, outdoor space, and it even has the room sizes. But when you actually go into the agreement, the APS has 0 square footage and 0 room measurements, because we've seen it that, one bedroom is like 10 by 10, turns out to be 9.6 by 10. And, each room, gets affected a little bit. And at the end of it, you got a few square footage shaved off the entire suite. I've seen it as much as over 15%. I think like there was a case that we had, it was 16%. And that's when I realized how they actually measure the square footage, because my understanding was like, okay, whatever it's between the 4 walls, that's what gets measured. Actually, no, it's actually coming from the outside of the exterior of the door, goes all the way to the outside of the window, and it goes from the middle of the demising wall all the way to the other one. And well, these things will add to the square footage that you're buying, but realistically you're not using it. So, and imagine few things get shifted. I had a condo that right off the get-go, like there was a massive ductwork that came on the corner, and few things got moved around. So there was about like, I think 5% of the entire square footage gone. And not to mention, like, my washer and dryer was moved all the way to my kitchen, and my den was like, chopped off because of the dock work, and a lot of things got affected. I couldn't get out of the deal.
No, actually, because a lot of these pre-construction contracts actually specify that may happen. So that's why it's important that you have those 10 days to speak with a lawyer and really understand what are some things that you may be exposed to. And yes, different square footage is actually spelled out in the contracts, and they specifically state that the square footage may be effective, and the floor plans may change as we need them to. So these things are actually written in the contract to allow for things like this. So, but one can argue that, if the square footage is of 25 and up, I would have to look at the case law, but that's where you have to look at, well, what constitutes as a significant deviation.
Well, that's the whole thing. What is the significant variation? Because when we had that case and the square footage was well over, like, it was 10, I think 15 or 16%. By the time they came back with the actual measurement, it went just over 10%. And I think we had the lawyer, the client called called Terion, and Terion said, everything within 5%, 6% if it is within the range, but this was just over 10%. Their lawyer said, listen, I don't think you have much case, you have to close on it. And it was upsetting to the client. In that case, the builder actually adjusted the price. They made it, because again, builder's reputation is on the line. You don't want people going around right now with internet, writing these things and affecting the builder's reputation. But realistically, how much leeway do they have?
So I would have to look at the case law when it comes to that. But, I don't think if in the contract it states that there may be, if the contract is silent, they'll have a better case, especially if what's considered a significant deviation, if the case law is saying, hey, it's in or around 5 to 6%, and the contract is silent about it, they may have a stronger case. But, I think you're not going to get the sympathy of the court if it's around 10%. I would really start looking at it and seeing what you can do if it's above the 25% point. And also, you, again, want to go back to the case law to see, well, what did the courts consider a significant deviation? And were those the cases where the contract was silent, or did the contract speak to it, right? But yes, this actually brings it to my next point, which is inspection, right? In Ontario, unfortunately, we don't have a statutory right to get an inspection. And I think when it comes to pre-construction properties, that's more significant than anything else, because you're buying a product that's not yet built, right? You're buying the right to buy a product. So when it comes to inspection, unfortunately, even though we don't have any statutory rights that grants us the right to an inspection, there was a BC case called Chased and that basically says there is an inherent right to an inspection. So this case, I want to look into more, and I'm really intrigued by it. But basically, what the court found was that sorry, I just want to bring a defendant have the right. Okay. So the defendants had the right to inspect the apartment before closing, even though that was not a right that was granted under the agreement of purchase and sale. And that the defendants were then, which are the purchasers in this case, they were actually entitled to terminate the contract, and they found that the vendor was in breach of the purchase agreement. And the right to inspect the apartment was implicit. So even though it wasn't explicit, it wasn't written, the court actually sympathized with the purchasers and found that that should be considered an implicit right. And basically the courts commented saying that it's ludicrous to think that someone would be investing over $5 million without an inspection. And other cases found that actually where there is significant deficiencies and where the consumers are being denied the right to inspection, that actually goes against the good faith provision that you need to basically you need to do dealings in good faith. So all this is to say is that if you are wondering whether these deficiencies are significant, make sure you write down that you want to request an inspection, and more so than that, make sure you're negotiating your agreement of purchase and sale with that right in there, especially when it comes to pre-construction properties. We had one builder that told my client that no, it's policy to not provide inspection, and to me, I think that's ridiculous, and Ontario government needs to do a better job with providing consumers with protection, such as a statutory right to an inspection of a pre-construction property.
At what stage?
Pre-delivery inspection would be a great part.
So we have the PDI.
You have the PDI, but that's not an inspection. And my client got denied bringing an inspector to the PDI.
Oh, you're talking about an inspection with an inspector.
Yes, absolutely.
So let's say if you're doing a PDI, you have the right to bring an inspector with you.
Exactly. And technically, you can proxy an inspector, but then you have builders that are saying, no, it's our policy. Well, why is it a policy to deny someone inspection when they're purchasing on average a house that's above $1 million?
So it's really interesting because I didn't know you can't bring an inspector, but I have seen some builders.
It's not that you can't, it's that there's no statutory right, and some builders may deny you that right.
There are builders that will deny anyone, even agents, going in with the purchaser. And during COVID, they were blaming it on COVID. They're like, oh, only one person. Or if there's two purchasers on title, they check ID and they will let them in, because we usually go with our clients. So anyone that purchases pre-con with us, when the PDI comes, we're always in touch with them from the time they buy till closing. So we tell them, listen, design stage, let us know. PDI, we always go with them because, again, we know what to look for. A lot of people can't. And what was interesting was there are some builders that even today, right now, that no one really denies people for COVID reasons. They say, listen, only the person on contract can show up. So if that person is a kid, we've had that, like, listen, that's what it is.
Well, and I think that that's absolutely ludicrous. Again, because of the nature of pre-construction, you're not looking at the property. You don't know what you're going to be receiving. So inspection should be a right that's granted with respect to all properties, but especially with respect to pre-construction, because again, you don't know what you're buying.
Yeah.
And actually, I did want to highlight this case where it says it was an Ontario Court of Appeal case that where purchasers discover significant defects in property that were not disclosed by the vendors, and those defects would have influenced the purchaser's decision to enter into the agreement of purchase and sale, has the right to terminate the contract. Well, with pre-construction, the builder can't disclose any deficiencies because the property doesn't exist, right? So again, if we have a 2011 Ontario Court of Appeal that says if defects are not disclosed and it would influence the purchaser's decision to buy it, then they could terminate it. Well, what can argue that in a pre-construction property, obviously, if you're the final product, it has significant deficiencies, that, and had you known that, you wouldn't have entered into this agreement of purchase and sale. So again, I know I'm saying this a lot, but I do think Ontario has to do a better job providing consumers with more protection when it comes to pre-construction properties, because we have, unfortunately, and you can speak to this more, we have seen a significant decline in the quality of work and the quality of the pre-construction products that are coming in the market. And I'm getting this sentiment from not only purchasers, but also builders and agents like yourself.
Yeah. What's interesting is there are some builders right now that have really upped their game in terms of the quality of build and the inspection.
You want to give a shout out to them?
I was just thinking about it. I don't know if I should, but you know what? I'll give it. Why not? Like, I mean, like, let's just talk about Tridel. Like,
I know. I was going to say, good job, Tridel. Yeah.
I mean, we go to a lot of PDIs, and recently there was a project that they finished. So I had a bunch of my clients, call me, hey, listen, we're going to PDI. Like, the amount of times I walked into this building, it was just like the girls that were doing the PDI would know me. And I was just shocked, the quality, like few of these units, because whatever, like maybe they had a cancellation or whatnot, the rep went there and started marking everything. And I'm picky, let's say. I went there and holy, it was so done nicely. First of all, the things that we're picking up was things that most builders wouldn't even pick up on. And second, there wasn't any major things that were missing. In most of these units, there was almost nothing that I would say is major. Like, there was like nicks and knacks on the walls and whatnot, but like there was literally nothing major. And some of these units were like so clean. I was like, this is like move-in ready right now. And that was really interesting to me because let's just say, like, I had gone to a few of the Tridel PDIs a few years ago. They were amazing, but this most recent one in 2024, it just blew me away.
Which project is this?
This is Auberge on the Park.
Nice.
It was just insanely well put together, and I was just blown away because you don't see that happening. I'll give you an example. I think it was during COVID. It was 2021, towards the end of 2021. It was fall, and there was a PDI that a client of mine called me, and they hadn't purchased a condo with me. So these clients bought it like.
Don't you love that?
Yeah, and they're like, listen, you know what, this is happening. What do I do? I'm like, listen, I'll come with you. Doesn't matter. They're a great client right now, and we go there. They don't let me in. So I'm like, well, what do you want me to do? So anyways, we had a checklist. I sent them the checklist. I'm like, listen, just go through this. And I never forget the guy that was standing there from the builder literally got so annoyed that I sent that checklist. So this guy goes there and it starts FaceTiming me, and the guy was not having him communicate with me. I'm like, seriously? Like, the guy just bought a unit. The funny thing was they missed a door to the balcony. So he paid for an upgrade to have an entrance to the balcony from his kitchen. They misplaced that.
Oh no, did
they
fix
literally
it after?
misplaced that. We sold that on assignment, so
someone else's problem.
Because he was so pissed off. Like, how do you miss a door? And they're like, listen, the whole window's got to come out, and they give him an estimate of like at 4 to 6 months probably.
Oh no.
And to add to that, there was a bunch of other things that he upgraded that weren't done, like even the counter. The thickness of the counter was totally wrong.
Oh my goodness. Well, you made a really good point, which is it's not uncommon for pre-construction sales to happen without a purchaser being represented by an agent. And, there is that 10-day period. But unfortunately, purchasers, if they're not specifically told that, they're not aware of that. And there is a power imbalance, right?
Yeah.
Especially if you have a first-time buyer or even a purchaser of a pre-construction unit that has never bought a pre-construction unit. They're not represented, right? So that's why I think Ontario has to do a better job of protecting consumers in pre-construction sales, is because of this power imbalance that happens too. You have a builder who is doing this on a regular basis, who has all the lawyers and the agents that they need under their belt, and then you have a purchaser who might be a first-time buyer and really not understand what they're getting themselves into.
And this is the problem, because I was talking to a lady recently, and their friend had a bad experience with purchasing pre-construction. They didn't cap development charges and whatnot, and she was mentioning the fact that, on closing, we got hit, like my friend got hit with, X amount, which is insane. Like, if that would happen to me, I wouldn't be able to close. I'm like, I understand that, but you can't just like paint everything with one brush and say, hey, listen, you know what, I'm not going to buy pre-con, I'm not going to buy assignments because, I'm going to get screwed at the end. No. First of all, if you're buying from any builder, you got to know who you're buying from.
Yes.
So you got to do your due diligence. You got to do your research. Second, if you're using the builder or the builder's rep to purchase, then you got no representation. So you have to have either your lawyer looking over the contract or even go with an agent so they know what to negotiate. A lot of these pre-construction condos, they don't offer, for example, cap development charges off the get-go. So if you were to walk in to the sales office, you think that rep is representing you, they're not. They give you a contract, you sign it, and it's done. You don't have cap development charges. You're going to get hit with like park levies. You're going to hit with a bunch of other things.
Oh, assignment rights. If you want to assign and you didn't negotiate the right or the price.
There you go.
Sometimes they'll say, yes, you can assign, but then it's going to charge you, we're going to charge
there
you $30,000.
You go. So that was another one. So recently someone contacted me. They wanted to assign a condo. And she's like, oh, I have assignment. I'm like, yes, but is it free? Like, oh, no, we have it. You have an amendment. Anyways, she didn't even have the full APS. It took us a long time to get the full APS. She had the right to assign for $10,900.
That's not even that bad. I've seen
plus,
30,000 and up. Yeah.
So this was $10,900 plus lawyer fee and.
Oh yes. You have to pay for the vendor's lawyer fees.
So I'm like, you do have it, but it's not free. And she's like, oh, I thought it would be free. But again, not blaming the builder, it's just like this consumer was buying her first pre-construction condo, doesn't know how this environment works. And that's why I think it's really crucial for government to step in, for consumers to get educated, to know, okay, at the purchase stage, this is what I need to look for. But like, I've looked at it, my lawyer has gone through the entire contract, but then I'm getting this product, it's got so many deficiencies. What then? Where do I go and, file a complaint, or what recourses I have? Because there were condos, let's say, near Midtown Toronto, on occupancy, the balconies were all shut. There was no railing on the door, and they got forced into closing.
Yeah, well, that's not considered significant, and you would have to close, and then that would have to be dealt with post-closing. Again, it's very, very difficult to say deficiencies can be considered a fundamental breach by the vendor. The deficiencies have to be, again, a lot in both magnitude and volume, right? I actually wanted to review this PDI with you to get your perspective if you think that this is a habitable residence, because there are a lot more issues that weren't disclosed here, like road access and just
Can we show the
structural
pictures
issues.
We're going to overlay the pictures.
Well, I'll get permission from my clients, and then absolutely. But I would like to show your followers because I thought that this was unacceptable. And I just wanted to videotape everyone's face when they were looking at the video because it spoke a lot. But this is what the PDI said. The PDI said there's no bathtubs, sinks, or toilets.
Like there was no bathtub installed in the house.
Well, it says damaged, incomplete, or missing.
Oh
and
my
underneath
God.
it says bathtub, sinks, or toilets. Bathroom accessories, mirror, countertops, cabinetry, which is okay, flooring, interior finishes and trim carpentry, furnace. So there's also no furnace. The windows don't slide. And on top of all this, exterior finishes, driveways, walkways, decks, and landscaping are incomplete. And on top of that, the house wasn't even fully painted. So they expected my client to move in while the house is getting painted and there's fumes in there, while there's no toilet and there is no bathtub. And also, I didn't say hot water heater. Yeah. There's also no hot water heater. And also, there's no road access, so city services can't even come. I don't understand. Like, in your opinion, do you think that this meets Section 13 of the Ontario New Home Warranties Plan Act?
I mean, like, listen, the whole point, I think, is, again, these are extreme cases.
This is an extreme case, I thought.
Builder pulls something like that, no one was going to buy from them. Like, I mean, we've had scenarios that the builders didn't, like, they were in occupancy for 2 years or delivered super late. Right now, as agents, we know, like, we're not going to be working with these builders. And, you know, if you go to any of these agents, they would be like, listen, do not go to that builder. And that builder right now is having a tough time selling. So things like that, the builders like this will not last. But it's just unfortunate because that client's experience is ruined and everyone around them will start questioning.
And also, like, the client now has to go fight in court to get his deposit back. So he's saying, hey, not only was I ready to close and I had everything in place, but also now I have to go spend money on lawyers like myself to go and fight in court.
Just imagine if they had sold their property, now they had nothing to move into.
Well, that's another thing. And then also imagine if they had sold it on assignment and then now there's another person that would be involved in this case, right? So I think Ontario government needs to do a better job for protecting consumers and holding builders accountable because, again, yes, one issue, I mean, you know, if one thing of this list was not working is another thing, but when there's a slew of things that are, you know, problematic and there's just significant deficiencies, it's unfair for the client to have to move into a property where it's, honestly, I would argue that it's not even safe for habitation at this point. If you still have to paint and you still have to finish the floors, the clients are expected to live there while all this is happening. That's unfair. And again, providing reasonable opportunity for builders to fix its deficiencies, we went back and we said, listen, it's fine. Take 2 months. Take as long as you need in order to be able to close this. They came back saying that, no, we're going to do it in 7 days, but your client has to waive their right to delayed compensation. Well, this delay happened because of your failure to provide a product that meets Section 13 of the Ontario Home Warranties Plan Act. Why should my client have to waive their right to delay compensation because of your failure to deliver the product, right? So
let's talk about delayed compensation because I know a lot of people are not familiar with that.
Yes.
We'll cut these parts out.
Absolutely.
That's for the occupancy, right?
Yes. So no, it's for final closing.
Final closing,
right?
Okay.
So when you're looking at the APS.
We're good?
Oh, okay.
You didn't need to change anything or no?
No, I just think it got a little hot. That's all. So just restart from.
Okay, so give me 2 seconds.
Okay.
Let me just
Yeah, okay.
review. Because I know it's $150 a day.
Because there's another one that's up to $7,500. Is that the one?
Yeah. So I'm trying to remember.
That's the one.
It's $150 a day for a maximum of 7,500.
I think that's the one.
Yes. So.
Which is nothing.
Sorry, 1 second. Okay, perfect. Let's do this.
Is there anything else after that
No.
we should touch base on?
No. I
We
think
do
we're
touch
good to
base?
wrap up.
Okay.
I think we got enough content,
Yes,
right?
there's a lot, yeah.
Yeah.
Okay.
Okay, so
Delayed compensation, right?
yes. So when you're looking at delayed compensation, it's important for you to understand the critical dates and your rights, right? So we have the firm occupancy date, and that's the date that the builder agreed your unit would be ready to move into. If this date is not met, the builder has to set a delayed occupancy date, and you are entitled to delayed occupancy compensation, and that's $150 a day for a maximum of $7,500, and we'll go into that a little bit more. And then there's the outside occupancy date, and this is the latest date that your builder agrees to provide you with the occupancy of the property, and if they don't meet the outside occupancy date, then the unit is not ready for occupancy, and the purchaser has 30-day period to actually terminate the agreement. So until the builder passes the outside occupancy date, you can't really do anything other than getting delayed compensation. And then if they do pass it, you only have that 30-day period to actually terminate the contract. And then when you are applying for compensation,
So the delayed compensation is when they give you the firm occupancy date and they cannot meet that date.
yes,
Okay.
yes. And then the delayed occupancy compensation. So if occupancy occurs on a date after the firm occupancy date, or if you exercise your right to terminate the purchase agreement to delay as permitted by the addendum. In the latter case where in the case you are also entitled to full refunds. So we discussed when they pass the outside occupancy date, what happens is that you have that 30-day to terminate the contract, and when you do, you are actually entitled to a full refund of all monies, including deposits for extra, including anything that you paid for extra and upgrades. Delayed occupancy compensation is for living expenses such as meals and accommodation. We discussed is payable on a fixed amount of $150 a day for each day of delay until the delayed occupancy date or the date that the purchase agreement is terminated. Compensation is also payable for costs incurred by you as a result of the delay. For example, additional moving, storage costs, etc. And the receipts have to be provided. So it's not uncommon it's becoming more rare, but it's not uncommon for the vendor to just provide delayed compensation on the statement of adjustment. So instead of you applying to carry on, the builder might say, okay, we're just going to give you the credit on the statement of adjustment, and we'll deduct the amount that you'll have to bring in on the day of closing.
Interesting.
So it's always a good idea to see if the vendor is willing to provide it before you actually go and apply to Terion.
Interesting. So I think we pretty much covered a lot of stuff, especially because right now pre-construction is a hot topic. So if people need to get in touch with you, if they have any pre-construction issues with the builder, can they?
Absolutely. You can Google Cactus Law Toronto and we'll come up, or you can follow us on cactuslaw.to on Instagram. We have great content.
We'll put
It's
the
very
information down below so they can follow you. Again, thanks for joining
you,
us.
Nima. It was a
And
pleasure.
hopefully we'll have you another time. We'll talk about maybe
Sounds good.
assignments.
Sounds great.
Why not? Okay.
Why not?
Guys, thanks for watching, and make sure to watch our last episode with Chris Slydom talking about just overall how the market is doing, especially right now that the rates have dropped. Thanks for watching, and we'll see you next time. Bye-bye.